Hi everyone, welcome back to my channel. Today we're going to be reviewing the hearing in the Lori Vallow Chad Daybell cases. Today's February 17th, 2021, and this hearing went down via Zoom. You have Judge Stephen W. Boyce of the District Court of the 7th Judicial District of Idaho, and you have Rob Wood for the state of Idaho. Mark Means is the attorney for Lori Vallow Daybell, who has waived her appearance today. John Pryor is the attorney for Chad Daybell, who's also waived his appearance today. After all, this is just a hearing on discovery. And you have Tina Gibson, the court reporter. All are here, all are present. So to give you a quick sum up, if you want to know what the verdict is and you don't want to wait, spoiler, here you go. On the motion to compel witnesses that was filed by Mark Means on behalf of defendant Lori Vallow, the judge has granted the order, and I'll explain, if you stick around, what that means. Also, in the motion and the potential order regarding the attorney-client privileges, that's the second item at the bar today, again brought by Mark Means on behalf of Lori Vallow. That is essentially, wanting to get her a cell phone, that's denied. So if you're sticking around to hear the play-by-play, let's get into it. First, the court went into a breakout session. That's the way for them to go off the record in these Zoom calls, or at least go have a little bit of privacy. They came back on the record at 11:44 a.m. There were two issues. Two motions before the bench, both brought by Lori Vallow, and Mark Means was arguing them. First was the motion to compel witnesses. This was first filed on January 8th, 2021. The second thing that's going to be before the bench is a motion and an order directing attorney-client privileged communication. Again, this was filed by Lori Vallow. So Means gets to argue first because he brought the motion. And he says that the defendant is asking for the communications between the state's attorney Wood and specific individuals on an addendum B. Okay? So there's an addendum B, and it's a list of individuals. And Means is stating that the state did not respond in a timely manner to this earlier motion to compel that was filed on January 8th, 2021. And Means asked for the emails, the cell phone, texts, the verbal statements, any of those kind of things between Wood and these specific individuals, saying essentially that they asked for these things back, they being the defense, asked for these different things back in December, and that there was simply no response at all from the state. And according to Rule 16, this other party, in this case that would be the state, has 14 days to respond or to object, and therefore the state waived any objection because they didn't do anything. They didn't respond and they didn't object. And Means says, we're not asking for any notes or any kind of memorandum. We're not asking for work product. And Means stated that Wood, the state, had conversations. So Wood had conversations with Summer Shiflett, the Woodcocks, Colby, and so on. And that Means wants the information. Means stated that Wood, 1, made himself a witness, and 2, is collecting statements. And that those statements could possibly negate the guilt of my client. In other words, be exculpatory, which we know via Brady, we definitely want to make sure we turn those statements, that information over. So Judge Boyce then asks Means about the addendum B, the witness list, and he's kind of challenging Means. He says, you said that there hasn't been anything essentially turned over, but the state has made some subsequent disclosures. So the judge, in essence, wants Means to specify about what he still is needing in discovery. And Means says, essentially, we didn't receive a response to this specific discovery request. Now, he's pointing out, again, this addendum B, and that he didn't get anything back about that. And he says some people are left off the witness list. So the judge turns to Mr. Wood, who it's his turn to speak, and Wood states that Means' timeline is actually correct. but that Wood had, quote, good cause that they failed to respond to Means's motion. And there's essentially a question about what grounds there are for good cause. Like, what gives you good cause to not do your job, right? And his position, Wood's position, is the motion to compel was improper and illegal on its face, all right? And I just got to say this, regardless of whose team you're on, all right? Because I'm on Team Kids, by the way. That's whose team I'm on, right? I'm not on anybody's team on, when you see this Brady Bunch of pictures here up on the Zoom, there's nobody here that I'm on their team. I'm on Team Truth, Team Justice, Team Kids. So I just want to say that. Note, please, the state should have objected and not ignored this. Doesn't matter if he made a ridiculous request. You don't just get to ignore things because then in a certain time period it's deemed waived. So it's always important to object to something if it's foul and explain why you're not responding. Ignoring things gets you here. Rant off. Wood also says, other than the good cause, they also states the work product issue. See, the state is allowed to have their own notes and their own concept of how they're going to move forward, and that is not discoverable to the other side. Judge Boyce point blank asks, basically, haven't you waived your objections by not timely responding? And Wood acknowledges the response is 8 days late. He cites this motion to compel was filed during the same time frame as the motion to disqualify the prosecutor, which is himself. So in a way, it's kind of led you to believe that maybe either A, it got lost in the shuffle, or B, he was overwhelmed. I don't know. But the state, again, cites its good cause and its excusable neglect. In other words, I had a good cause reason not to respond, and even if I didn't respond and I should have, it's excusable neglect. And he tells the court that in the cases of good cause or excusable neglect, the court can look at it. The judge then says, let's look at what's discoverable. He cites Rule 16b-6, and the rules essentially, if someone will be called or may be called by the state, it needs to be provided to the defense. And Wood cites case law, and he says, well, not all comments are statements. Statements need to be provided if it's an actual physical statement taken of the witness, but not every random comment is a quote-unquote statement. And he asserts that just meeting with witnesses and going over their current testimony is not a statement. And it's not a Brady violation, because these are not inconsistent statements, like statements already given to law enforcement. And Wood essentially says that Means is making an illegal request. So the judge again goes over the rule and says that the prosecuting attorney must provide the name of who they, who did they talk to, and 2, did they say something about the case? The judge looks at the procedural argument, the argument of the process of this thing, and he notes that the defense asked for the information, asked for it through writing in the motion, and they received no response from the state. And the judge is quite concerned with the state's timeliness of their response. Then Wood says, if the court orders us to provide it, we will. I don't believe every conversation with the witness is a statement. So it's either A, not a statement, or B, it's work product, or C, it's outside the scope of Rule 16. John Pryor is then allowed to speak, and he voices his concerns that the Wood defines what he thinks is relevant evidence. He says, it's not relevant, so I won't respond. I won't answer. He doesn't get to decide what's relevant, is what Pryor says. And he accuses the state of slow walking their motions and also sandbagging. And he threatens, we'll visit this again, essentially on behalf of Chad Daybell. He's the attorney for Chad Daybell. And this initially was brought by Mark Means. And so, the judge kindly reminds Pryor that if it is going to be visited again, that he has to file his own darn motion. Judge Boyce then rules on the motion to compel, and he grants it. He says that the state did not object in a timely manner, but there's no ground for sanctions, so Rob Wood is not in any trouble for this. The court has discretion about the sanctions under 16, I think it's F2. Sorry, sometimes I can't read my own darn handwriting. Is that not pitiful? Anyway, so there's a question whether the prosecution or the prosecutor discussed the case to those individuals in Addendum B, and the judge accepted some parts of that addendum. There's portion 25 to 27. He thought those were too broad a request, but he says that the state did not have to turn over any kind of work product or any kind of, their own written notes. But, however, written statements of these witnesses on Addendum B, those need to be turned over. If they talk to a witness or potential witness and they provided relevant facts to the state, they need to provide a summary of those statements to the defense, okay? Honestly, let's break this down, because people, they realize that, yes, Means made a motion that was granted, okay? Yeah, we get it. What does this hurt the prosecution? All this means is that Wood has to go down through that list, see if he did any extra talking to these folks via text, via email, or an oral statement that wasn't reduced to writing that included any kind of quote-unquote relevant fact, okay? Anything exculpatory, anything new, and all they have to do is reduce it to a summary and give it over. So it's not like they lost the case or anything, guys. It's just some extra work that they need to do, and honestly, they should have done it anyway. You do it's like a supplemental report, If people call you up or email you and say, hey, by the way, I remembered this, da-da-da-da-da-da, will you write da-da-da-da-da-da in a supplemental report and you hand it over via discovery to the defense. And this is, again, not team anyone. This is team let's have a fair trial, because if you let things like this slip through the cracks and say, oh, we love Rob Wood so much, let's forgive this and just ignore it, what happens is you get an appeal, and it causes an appellate issue, a very clear one, because you're not allowed to have anything that could be, say, exculpatory not handed over to the other side. That's that's going to get you a new trial and maybe get you off. I mean, do you want that just because you're in love with Rob Wood and don't want him to lose a motion? This is no big deal, really. In the long scheme of things, this isn't a big deal. He has to go and look through his files, look through his emails, look through his text to see if there's anything that was relevant, and all he's got to do is either hand that over as it is in its form, or if it wasn't something that was given to him orally, reduce it to a statement and hand it over. I get the impression, if you want to have me speculate, something was said that maybe applies to the death part, but not to the cases that's right in front of the court at this time, and maybe he doesn't want to hand that over yet. And I think it might have to do with Summer Shiflett. Again, this is my opinion and this is my speculation, but there's something that was said that he hasn't handed over because it wasn't applicable to this particular case, but maybe it's applicable to like something else. And that's part of this drama. So Rob Wood told the judge that he could provide this information to the defense in 14 days, and the judge agreed that that was an acceptable time period. So now, after 14 days pass and whatever is given over, if there's anything to be given over to Mark Means and to John Pryor, and if they then squawk and file more motions, we'll know about it. We'll know about it if there was something really important and some kind of bombshell that wasn't given over. We'll surely know, because I'm sure they'll squawk about it. So moving on, there was a break, okay? A break for the court reporter, I do believe. And then we had a second motion order heard. It was 12:49 at this time. And it was the motion filed by Mark Means on behalf of Lori Vallow, regarding the attorney-client communications, because meeting with the client, Lori Vallow, has been real difficult due to the COVID, which is no surprise. Means starts off citing the Sixth Amendment, the defendant's right to a fair trial, and Means talks about equality in an adversarial situation, and that he's only seen Lori Vallow a few times, like 6 times in 12 months. And then he talks about also being denied 6 times, another 6 times, and that at least 3 of their privileged phone conversations were recorded, which again is a humongous no-no. Those recorded conversations, their attorney-client privilege, were given to the detectives and the prosecutor. But mind you, in the whole thing, it was actually Means' fault, because he was supposed to be given using the certain code to signify that he was obviously her attorney, and therefore then the conversations wouldn't be recorded. But I guess he didn't give the jail that number or something, so it's actually his quote-unquote fault that it got recorded. But nevertheless, once it was handed over, they recognized what it was, that it was attorney-client communications, didn't listen to the calls, but still, that is a problem. So allegedly, Wood remedied that problem when he saw that those calls got recorded, and he went ahead and gave the jail Means' number. That's remedied, but there's a problem, because it's a high profile case. He needs to see his client. Means talks about the different options he currently has to speak with Lori Vallow. One of them has him putting in a code every 10 to 15 minutes. And he knows that the female and the male detention centers have different results. Like apparently there's no problem with John Pryor seeing Chad Daybell. And he's just having all kinds of trouble getting access to his client. And last time he had tried to see Lori Vallow, he was told that he needed an order to do so. And he just notes that it's impossible to prepare an adequate defense in these circumstances. Means tells the judge that he would like to see Lori in person, and he wants to at least see her in the attorney-client room that they have set up there, that sometimes he's told he needs an order to use. And he would also like the security cameras off. Or in the, if you can't do that, judge, let's give her a cell phone. He brings that up as a possible solution, that saying that, the cell phone would be paid for out of the client's money, and that the only number that would be called would be his number. Now, that is not going to happen for a multitude of reasons. Cell phones are considered contraband. That is just not going to happen. The judge is not able to tell the jail what to do. That is not how the world works. Everybody's got their own kingdom, and Judge Boyce is not the kingdom of any of the jails. So he doesn't have the right to just allow something that's considered contraband into another institution. And then the minute, let's say that it did happen, the minute Lori got one, everybody else in the jail is going to have one. So you can't have one person be special and everybody else just sits there. No, then everybody's going to have a cell phone. And if that happens, imagine all the shenanigans the prisoners would be doing with their cell phones. And by the way, I know a little something about prison phones from employment. And all the prisons, as far as I know, have contracts for their systems, their payphones, right? Their telemate and stuff like that. And a lot of those contracts, they don't allow for other people to have phones. So the prison is already under a contract with these different companies. It isn't going to happen. It couldn't happen. The judge couldn't allow that, and so he didn't. I mean, that was just almost it was laughable. Can you imagine Lori having a cell phone, and who would be the first person to roll her over for that phone? Oh, Lord. Some big mama in jail would roll over Lipstick Lori for her cell phone. Can't you see it now? Woods asked for his opinion, and he says he objects to the cell phone. He objects to turning off the security cameras, but other than that, he doesn't object to anything else in Means' motion. But Wood doesn't tell the jail what to do. He knows that, and he doesn't tell the jail who sees their attorney. Judge rules that Means can use the attorney-client room. The judge is also unaware of any black box technology that was mentioned. The request for defendant Vallow to have a cell phone is denied, as it is outside the scope of jail policy. And a dee-ba-dee-ba-dee, that's all, folks. Essentially, Mark Means here in the middle. You see his little jackalope artwork piece here has actually won one. He actually got his motion granted, and Rob Wood doesn't look too happy. He's probably got some emails to scroll through and some text to scroll through, and either to turn them over as is or to make a summary and turn it over. She's just got a little extra work to do, that's all. Lori's not getting a cell phone. And what this does, okay, if you want to say, well, what's the point of this? It's just making a record. Mark Means is making a record to show the court, hey, I've had trouble getting access to my client. This is kind of the stuff that went down, and it's now in the record if he ever wants to use it on appeal that he had trouble getting access to his client. So that was kind of the reason that he filed a motion like this. But that's all, folks. I hope you enjoyed this commentary as told by Theolyn. If you did, please push the like button and please subscribe for further updates. And without further ado, have an excellent day.